The next case to come before the court is Susan Wilson versus Robert Wilson. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know, as I will be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of children or minors, or should it be relevant victims during your arguments, you can refer to those folks by initials and terms like the child. The judges have read your briefs and are ready to proceed when you are, so at this point I would just ask the appellant, would you like to reserve time for rebuttal?
Yes, Your Honor, if I may reserve 5 minutes.
Very, very well, and as I said, when you are ready, you can proceed to the podium. Please introduce yourself, and we're ready when you are.
Thank you. May it please the court, I'm Tom Lepp, I'm representing the appellant Robert Wilson. I don't think this argument is going to go very long here, so you've read the briefs, I think you have I'm sure you have a good grasp of the issue here. Basically what we have is a judgment entry that provides different incomes for different situations and then double dips on some of the income as to a property settlement. So we have, you know, in rough figures, we have my client's income being determined to be $137,000 at one point, and at another point being considered to be much less for the purposes of child support. So for his.
I'm not certain I saw that, Mr. Lepp, but looking at the decision below there, I think in paragraph 90, where the judge found that the income for child and spousal support was the 137 or so figure you're talking about. In looking at the guidelines, it seemed to me on the guidelines, and I think the FinPlan may have been attached from remembering the record, it also seemed to me she's indicated support was the 137 or so figure that we're talking about, which I assume includes regular income plus the bonus from the stock.
Correct.
And that's the 137.
Correct. She's included regular income plus the bonus, but for the purposes of child support is not including the bonus for that purpose, which does not make sense with this situation. Plus, that bonus is also being split up 50-50 between the two of them as a property, as a property in a double dipping situation.
If I understood the order, it was the account that existed where the bonuses went was going to be split 50-50.
Correct.
And the court wasn't doing what I would call a phase 1 and phase 2 support where they were going to split the bonuses as they came in. Is that correct? The court just kind of figured out the income's 137. We look at that and it calculated support.
Correct. Right.
Okay.
Right.
Okay. I just want to make sure I understood that properly. So there wasn't any kind of, every time the bonus came in each year, that would be split 50-50.
No. But the court has also made it impossible for my client to pay his child support, and also impossible for him to comply with the court orders, since the court has also put on orders that he is not allowed to touch the funds in the account. The court turned around and then froze those same funds, so he can't access those funds.
And it seemed to me you had made some filings regarding that.
Correct. We have.
And then you filed a notice of appeal. The judge stayed everything and never ruled. Is that kind of fair? That would happen to the rulings? That's
a fair statement. So that ruling may not even be before you, but from a practical standpoint, my client is it would be technically in contempt every day of the week for not having the ability to comply with the court orders. Number one, with respect to support, and number two, with respect to the property division. And as we've indicated, we take the position that taking and determining the amount of support for child support versus the amount of support for spousal support, and then taking the funds from this account and ordering them to be split, we take the position that is double dipping. Thank you, that's all I have.
And you will have your full 5 minutes on rebuttal.
Thank you.
Good afternoon, may it please the court. My name is Leslie Grasky, and I'm here on behalf of Susan Wilson. I think there's a nice analogy that would make this more understandable. If we take the Tesla stock bonus, which shows up as W-2 income, and then it's just money, and then he took that money and he put that money into a bank account. The money that had accrued during the marriage pursuant to statute would be divisible. And then his future bonuses would be considered as part of spousal support or child support. I think that, frankly, Mr. Wilson has benefited magnificently by his bonuses not being used in his child support calculation.
Well, I am still confused about that.
Me too.
Do you agree that they weren't? Do you agree that, did you review the guideline amounts that you're on the case and appeal on anyone trial counsel? Did the guideline amounts include the 137 or so for income?
I believe it did. Child support not being an issue, I didn't.
Right,
my
and
worksheet
I
with me.
appreciate that too. But
And the court calculated child support on a temporary basis on a low figure. And that's where I say he benefited from that. That's not a harm. The money that he was accruing as bonuses during that period just became an asset, like a cash bonus would become an asset if you could trace it. It wasn't.
and that's in essence how the court treated it when they set spousal support here, is they figured his income for spousal support was the 137, so they were including this stock bonus as part of his income. Is that
Yes.
your view how the court
Yes,
ordered
it
it?
was.
Okay.
Yes, it was. So the court divided an asset in the past, which had accrued. That's how you do this. And then the court used the ongoing bonus figure in determining income for support purposes in the future. This is not a double dipping situation. That would mean that if the court had considered the dividends on Mr. Wilson's half of the Tesla stock account, the E-Trade account, as part of his income, well, that would be double dipping, because she got her half of the pot, and then it wouldn't be fair for her to get the dividends. If for some reason the court had considered the value of Tesla Corporation and had used that to determine the value of his Tesla stock, and then had used that as part of his support figure, that's really technically double dipping. You own a business, you value the business based on its ongoing income, wife gets half of it, and then it's error to award wife future spousal support on the income from that business that's been divided. I don't believe that's what the court did. It would be instructive if Mr. Wilson's complaint regarding freezing the assets could be addressed, even in passing, because it benefits both parties for him to be able to effectuate the terms of the decree.
Is there, in your view, still an order on that prohibits him from accessing the stock at this point?
Yes. And, the order was not ruled out before the notice of appeal, so it's not technically before you, but it's hard to fathom.
So there is an outstanding motion requesting him to be able to access that account.
He certainly tried to do that.
But there is one filed, the notice of appeal interrupted the process
Correct.
on that being determined.
Correct.
In your client's position, I take from what you're saying, is yes, you would certainly agree that the stock ought to be able to be sold, he should have access to sell it as soon as possible.
Yes, sir, Your Honor. Excuse me. If there are no further questions, I will remove myself. Thank you.
Very well, thank you very much. Attorney Left, you have 5 minutes for rebuttal.
I'll waive the balance of my rebuttal. Thank you.
Very, very well. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website.